Today is a big day for the president of South Africa, Cyril Ramaphosa. If he wins this particular case in the Constitutional Court, then the Phala Phala matter is fundamentally over, unless, of course, if the MK or another entity decides to pursue a private prosecution. If he loses this case, then the National Assembly may have to go to step 2 of an impeachment process, which is an impeachment committee. The impeachment committee has very strong powers and could expose a lot about the business that the president was doing while he was sitting as a head of state. In fact, the president was so afraid of this particular outcome at one particular point that it was rumored that he actually wanted to resign to avoid Parliament voting for there to be an impeachment committee. In this video, I'm going to share some of the main arguments that will be made by different counsel today in the Constitutional Court. I'm able to do this because I've gone through the heads of arguments of the different legal teams. The actual hearing will likely take quite a bit of time, but this particular video may help you to look out for certain issues and ideas and arguments if you have the time to watch, and help you to think through some of the issues for yourself. Usually, the South African Broadcasting Corporation, the SABC, will air the court hearings on YouTube. Sometimes will also post a link on their Twitter and other platforms. So look out for that. Today, arguing for the economic freedom fighters, you have advocate Camille Premid. Usually the EFF has been using advocate Dalim Pofu, but as you've seen, he's now closer to the MK party, but also he's not always won these types of cases. So they're changing their, brief and who they brief. So they've briefed advocate Camille Premid. He's an Indian gentleman who has argued several times before the Constitutional Court, and he has a unique style of presentation that I think you'll observe if you watch the particular proceedings. I actually like the way he presents his arguments, and I think he'll do a very good job for the EFF. But he's going to be going in against a lot of senior counsel and a lot of heavyweights who are going to be arguing against him. Arguing for the National Assembly and the Speaker of Parliament, you have got advocate Andrew Breitenbach, who is a senior counsel. Arguing for the president, and this is critical, you've got advocate Wim Trengove, senior counsel. Arguing for the ANC, you've got also a very high-profile celebrity advocate at this level, advocate Tembeka Ngcukaitobi. And arguing for the African Transformation Movement, you've got advocate Mfundo Mkhambi. I'm not very familiar with his style and his background, so I can't actually speak to whether or not he'll deliver, but we'll see. I've got a side note that I want to point out here, and this relates to advocate Wim Trengove. The president has essentially got the Michael Jordan of South African litigation on his team. That either shows confidence or concern. You know, when you're going to court and you get, like, for instance, if you get the lawyers who represented O.J. Simpson, you know, in America, in a criminal case, we know that, you're desperate, 2, you want to get the best people that you can so that you can get out of this tight situation. We saw that, with those 2 celebrities who had that case where, not Brad Pitt, what's the name of this Pirates of the Caribbean guy versus his girlfriend? I can't remember their names, but they got some high profile lawyers in that case because of the significance. So you either get a lawyer at this level because you're confident or you're concerned, right? Confident that I'm going to win, let me get the best. Or you're concerned, or maybe you're just a billionaire, that also becomes a factor. So advocate Wim Trengove specializes in administrative law, constitutional law, and human rights law matters. And he's best known for his appearances in the Constitutional Court of South Africa. The Constitutional Court is his backyard. He lives there. He's always there. As a law student, and if you didn't know, I studied law at the University of the Witwatersrand, and we learn a lot about cases that he argued in from first year all the way to fourth year. When you read the case judgments, when you see who was arguing for which team, one of the most consistent names that shows up is Wim Trengove. Personally, I had an issue where we were doing a moot court competition at one particular point, and we were dealing with the issue of silicosis. And this issue never really went to the courts to be ventilated properly because it was settled. But at that point, we were doing a matter which related to class action and whether or not you could actually put the miners who've been affected by silicosis into a class. And we were actually arguing the side which Wim Trengove himself was arguing, and I got to look at his heads of arguments, preparing for the case, etc. So in law school, you bump into this guy's cases. And if you guys are not aware, in the human rights area, Wim Trengove has argued for the abolition of the death penalty in S versus Makwanyane. That's a case every law student has to know back and front, S versus Makwanyane. He argued against the discrimination on the basis of HIV status in Hoffman versus South African Airways, another very important case. All of the cases I'm saying are important. For the protection of sex workers' labor rights in Kylie versus CCMA, for the restitution of land and mineral rights to groups dispossessed during apartheid in Alexco Limited versus Richesveld Community, for the rollout of antiretroviral treatment for HIV patients in Minister of Health versus Treatment Action Campaign. Other cases that he's argued in at the Constitutional Court, which are notable: Economic Freedom Fighters versus Speaker of the National Assembly, National Coalition for Gay and Lesbian Equality versus Minister of Home Affairs, Kruger versus President of the Republic of South Africa, My Vote Counts versus Speaker of the National Assembly, Corruption Watch versus the President. He's a winner. He wins a lot of cases. Winner, winner, chicken dinner, as they say. Trengove has been active in very high-profile political cases as well. He's represented former President Nelson Mandela, including in his divorce from Winnie Madikizela Mandela. He's led the prosecution of former President Jacob Zuma on the charges of corruption. He's represented President Cyril Ramaphosa in his disputes with the public protector. He's also been very outspoken about the NPA's 2008 decision to withdraw corruption charges against Jacob Zuma, criticizing the decision at a public lecture at the University of Cape Town, where he's an honorary professor. So he clearly doesn't like Jacob Zuma that much, but also he's clearly a very well-established lawyer, and he is the president's lawyer, president's counsel, Baba. That's not a joke. This guy is the gold standard of the legal profession. Everyone wants to be him. He's the Michael Jordan of the game. So you can see that the EFF is going, it's David versus Goliath. Advocate Camille Premid here is David. The Goliaths in the room are actually on the side of the National Assembly, the ANC, and the president. That's the reality. Okay, so we've covered that. Now let's go back to the facts. Let's quickly do a summary of facts. There's a farm in Limpopo called Phala Phala Farm, and that farm is involved in cattle and game farming and breeding. They sell, they cull, they buy. The owner of the farm is the Tivashe Trust. The company that operates the farm is Ntabanyoni Estates, and the president is the sole member of that company. The company hired 40 people to run the farm. The president has publicly said, I am a farmer, I'm in the cattle business, and I am in the game business. I buy and sell animals. That which is being reported was a clear business transaction of selling animals. He has said this, those are his own words. A burglary took place on the farm on the 9th of February 2020. An undisclosed amount of foreign currency was stolen from the farm at the time of that burglary. The crime was not reported to the police, and there was an unlawful investigation to try to recover the money that was stolen. These are the undisputed facts. Everything else is disputed. We just need to be clear about that. Now, what is applicable here in terms of constitutional law? The Constitution of South Africa in Section 89 speaks about the removal of the president, and it says, the National Assembly, by a resolution adopted with the supporting vote of at least 2/3 of its members, may remove the president from office only on the grounds of A, a serious violation of the Constitution or the law, B, serious misconduct, C, inability to perform functions of the office. There are rules that have been put in place now which stipulate how that particular process of removal of the president may happen. And these rules pertain to the creation of a Section 89 independent panel, then moving to an impeachment committee, then moving to the vote. So you can't just vote. You have to go through a particular process to remove frivolous claims. Now, Section 96 of the Constitution deals with conduct of cabinet members, deputy ministers. It says in that particular section, members of the cabinet, deputy ministers must act in accordance with the code of ethics prescribed by national legislation. Members of the cabinet, deputy ministers may not undertake any other paid work, act in any way that is inconsistent with their office, or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, and C, use their position or any information entrusted to them to enrich themselves or improperly benefit any other person. Now, we do know that this matter was taken to the Section 89 panel. Let me give you a summary of the events and how we got to that particular space. Arthur Fraser opened a case against the president on the 1st of June at a Sandton police station. On the 14th of June, the ATM party submitted a proposed motion to the Speaker requesting the House to initiate an inquiry into the removal of President Ramaphosa from the office. The Speaker initially declined the motion, and the motion had to be adjusted, but the motion was deemed to be compliant on the 18th of July. Rule 129C of the National Assembly requires that when the motion is in order, the Speaker refers it and supporting documents to an independent panel of experts. In terms of the rules, the Speaker must appoint the panel after giving political parties represented in Parliament a reasonable opportunity to put forward nominees. On Friday, the 5th of August in 2022, the Speaker of the National Assembly, Ms. Nosiviwe Mapisa-Nqakula, who's facing charges now of corruption, considered the motion in terms of Section 89 of the Constitution and Rules 129 A to Q of the National Assembly rules as introduced by the African Transformation Movement to be compliant in accordance with the rules. On the 14th of September 2022, which was a Wednesday, the Speaker of the National Assembly, Ms. Nosiviwe Mapisa-Nqakula, applied her mind to the 17 nominees and appointed 3 people to be on the panel. Number 1, former Chief Justice Sandile Ngcobo, Judge Thokozile Masipa, and Richard Calland, who is a professor of public law at the University of Cape Town. On the 27th of September, the Speaker changed the composition of the panel based on complaints that had been received from the Economic Freedom Fighters as well as the Democratic Alliance and other parties. She then replaced Richard Calland with Advocate Mahlape Selo, who is a respected senior counsel with decades of legal experience and served on the Judicial Commission of State Capture. On the 30th of September 2022, the Speaker of the National Assembly announced that the independent panel report would be released to members of Parliament, and that report actually found that President Ramaphosa had violated the Constitution and also had violated the law. They said, in light of all of the information placed before the panel, we conclude that this information discloses prima facie that the president may have committed a serious violation of Section 96(2)(a) of the Constitution, a serious violation of Section 34(1) of the Prevention of Corrupt Activities Act, a serious misconduct in that the president violated 96(2)(b) by acting in a way that is inconsistent with his office, and a serious misconduct in that the president violated 96(2)(b) by exposing himself into a situation involving a conflict between his official responsibilities and his private business. So that's what the Section 89 panel actually said. What are the different entities arguing? What is coming up in their heads of argument? This is what the president is arguing. Remember, I told you Wim Trenggroove, best in the business. This is what he's arguing. I'll tell you whether or not I think these arguments are strong at the end of the video. So here's what the president is arguing. Number 1, they're going to be saying that the president did not act in bad faith. They submit that this is the heart of the question in respect to the Phala Phala money and everything that followed. They say that Rule 129 says serious misconduct means unlawful, dishonest, or improper behavior performed by the president in bad faith. Serious violation of the Constitution or the law means that the behavior by the president amounting to an intentional or malicious violation of the Constitution or the law performed by the president in bad faith. Their argument is that the panel did not look into bad faith, and because it did not examine that question, the finding in and of itself is faulty and can rationally be dismissed. They also argue that sufficient evidence is a higher standard than prima facie evidence. Prima facie evidence, they say, is the threshold for the initiation of the complaint according to Rule 129A. But however, that sufficient evidence is the necessary threshold for progression of the complaint to the impeachment committee. They say that the language used in 129A and 129B is different. Therefore, these things must be looked at differently. They then say that because the panel did not use sufficient evidence and used information, therefore the decision that was made was not correct, and therefore the report was flawed, and that the panel misunderstood its mandate. Therefore, the National Assembly was rational and correct to actually not progress to the second step. Those are their substantive arguments. They also make a lot of technical arguments. They argue that the EFF had a political motive in bringing this particular litigation, that there was an unreasonable delay in making this particular litigation. The decision that Parliament made was on the 13th of December. The Concord dismissed the president's application for review on the 1st of March, and that the EFF only came on the 7th of February 2024. Therefore, the matter is late, and the matter is res judicata. What is res judicata? The doctrine of res judicata, also known as claim preclusion, is a legal principle that states that a matter has been finally determined, by a court of competent jurisdiction cannot be relitigated by the same parties or their previous in a later suit. This means that a judgment in a prior suit bars any subsequent suit based on the same cause of action. The purpose of the res judicata is to promote judicial efficiency and prevent the harassment of parties by multiple lawsuits. So they say, because the court dismissed this issue, therefore it's been heard, EFF should go away. That's basically their argument. They're saying that, look, this is a review by another name and not a declaratory order. They're saying that, look, the power of the National Assembly is permissive, not automatic, it's discretionary, and because it's discretionary, it's a political power. There's no application that the EFF has made for direct access, and there's no authority that the court has to substitute the decision of the National Assembly. That power is a political power that belongs strictly in the realm of the National Assembly. This is what they say. Now, what does the EFF say in response to some of these issues and in their own arguments? The EFF says the role of the Constitutional Court is to make sure that the president is held accountable and to prevent situation where the president's version has never been tested or where the president fails to account. So they say that the president's version has never been tested. And I want to just make a quick comment here because that's true. The president told something to the Section 89 panel, but he has told nothing to nobody else in full, right? They only have the hearsay evidence of Mr. Ndlovu and Hazim Mustafa. Hazim Mustafa, who has disappeared. He has not spoken to SARS. He has not spoken to the South African Reserve Bank. He has not spoken to the South African Police Service. We know that SARS already said that the money that he said he came in with, or the version that there's this guy called Hazim came in with some money, they don't have any records of that. So the president's version has not been tested. That's the main argument, or one of the main arguments that is going to be given. Then the second one that they give is that the reasons offered by the National Assembly for the downvote do not meet the test of legal scrutiny, right? They say that the panel, the Section 89 panel, did correctly understand its mandate, and the ANC MPs who said they didn't wrong and being dishonest. The reasons that were given by the members of parliament at the time of the vote on the 13th of December are the only reasons that should be evaluated, and they say that those reasons were more political than they were rational or lawful. They say that the ANC conceded that the purpose of their vote was to protect the president, and that also people were threatened and issues with threats, and Fikile Mbalula did issue people with threats that they should vote to protect the president. And they say this is what makes the decision in and of itself an irrational, unreasonable, and unlawful decision, the decision to say we're not going to proceed to the second stage. They say the distinction between prima facie evidence and sufficient evidence in this particular matter is arbitrary and is superfluous. They say that there are varying degrees of prima facie evidence, that the evaluation is different from that made by the speaker, and that the Section 89 panel was correct to use the information that they had to make the evaluation that they had. They say that the discretion to vote down the second step is not a wide political discretion. It's narrow and has to be in relation to the report that has been provided to them by the Section 89 panel. They say that the National Assembly has got the authority at the end to still vote against the impeachment committee deliberations and decisions. And that impeachment committee has to be allowed to do its work because it has real powers to subpoena, to examine documentary evidence, which the other Section 89 panel does not have. Technical points that they make, because those were their substantive arguments. What are the technical points that they're going to be making? Number one, the court has exclusive jurisdiction on this matter because the EFF is arguing that the National Assembly failed to fulfill its constitutional obligations. This makes it a case that can be heard only by the Constitutional Court. They say that because the court has exclusive jurisdiction, this obviates the need for them to make an application for direct access in and of itself. They say that the interest of justice in any event outweigh the delay objection. They say that there's no infringement on the separation of powers, and that they also say that an error of law can found a review process through the legality process, not necessarily through the Promotion of Administration and Justice Act, which is PAJA. So they say that judicial review based on legality is another path outside of PAJA, and therefore the argument that, hey, you're trying to do a review through a declaratory order in and of itself is immaterial regardless of how the court views that matter. They say that you cannot dismiss that issue based on the review and declarator issue. And then they say that the rule in and of itself remains vague in so much as it's open to abuse and these types of interpretations. So that's what the EFF is going to be arguing according to their heads of argument. Obviously, let's see what plays out. Here are some points I want to make. Some thoughts, having read these heads of argument. I'm keeping it short, so I don't want to go through everyone else's heads of argument. I'm giving you the main actors. There's something uncomfortable for me in the position of the president's case. I respect Wim Trenggroove, great guy. S versus Makwanyane, woohoo, you're the best, man. But I'm not persuaded. Here's why I'm not persuaded. The president's team wants us to trust that the president acted in good faith, but they never want that to be examined because they are blocking the next stage. They want the panel to evaluate, they wanted the panel to evaluate evidence at a level beyond what it was empowered to do. And they wanted the panel to duplicate the impeachment committee's work. The panel made it very clear in their report, the Section 89 panel, chaired by Chief Justice Sandile Ngcobo, who is a Harvard graduate in constitutional law, somebody who served as the Chief Justice of the Constitutional Court for 12 years, and somebody who served as a judge for a protected period of time, a legal professional who is esteemed by everyone in South Africa, and perhaps even the Michael Jordan of being a Constitutional Court judge, right? The Section 89 panel made it very clear that they had limited power to conduct the preliminary inquiry. And they specify from paragraph 69 to about paragraph 80, and you can go read this in the Section 89 panel report, which is available online, that they could only use the information placed before them by members of the Parliament, National Assembly, and by the President's response to this information. They were not empowered to hold oral hearings. They were not empowered to summon any person to appear or to give documents. They were not empowered to request any person or state institution to give evidence or to produce documents. This has a bearing on the argument of what manner of evidence they could evaluate, collect, and verify. What Wim Trenggroove is insisting on is a higher standard than prima facie evidence. But this seems to be a circular argument and one that defeats the purpose of the independent panel stage. Why is it a circular argument? because you are arguing for powers that the panel does not have to get specific outcomes, and saying because that panel does not have that evidence, therefore it should be dismissed, even though the panel doesn't have powers to get that evidence. That's the circular reasoning, the fallacy that exists, or even, if you will, a contradiction. Arguing that the panel did not get sufficient evidence while it doesn't have powers to get that particular evidence, and that arguing that its findings must be discarded because it didn't get evidence it doesn't have powers to get, seems to me to be a fallacy, and one that needs to be underlined and that we all need to be looking out for. That's number one. Number two is that there's a poison chalice in this argument, because the president himself can provide incomplete or self-serving evidence to the panel, and they just have to take his word for it. That's like in a situation where you found a child breaking a window, maybe you're the parent, and then you ask them what punishment do they deserve or who broke the window, and then just take what they say and what they advise. Kids typically will go for the smallest punishment available. I mean, Trevor Noah, who never jokes about President Ramaphosa, but jokes a lot about Zuma, has even made this joke about how if he was told to go and get a stick or whatever to beat himself, he would pick the smallest one. He would bring a twig after breaking a window instead of bringing, something more significant. The point that I'm trying to make here is that the idea that the person who is accused is going to give the most honest and best version, face value, and should never be examined, is one that only works if you trust the accused. If you think the president is Jacob Zuma, will you take his version for it without examining it? If you think the president is Julius Malema, will you take his version without examining it? What if the president is Floyd Shivambu and he's telling you that, no, here's what I know about VBS? Would you take that version without examining it further? So that's something that I think is a poison chalice. And I think also the argument defeats the purpose of the second stage. The impeachment committee has all of those powers, which they say they need to evaluate evidence properly. Powers to summon people, powers to request documents from individuals and institutions. Why would the preliminary stage have the same powers as the as the committee, which is going to do the full work? That's a duplication. And it doesn't seem like it's a duplication which was intended. The panel made it very clear that even the president did not provide them with full information. They were given sworn statements and those sworn statements came from only three people: Arthur Fraser, Benjani Chauke, and General Wali Rude. No sworn statement was provided by the president. No sworn statement was provided by Mr. Ndlovu. No sworn statement was provided by Hazim Mustafa, the guy who allegedly gave them the money. And by the way, I think Hazim Mustafa is a liar. Personally, I think he's a liar. Why do I say that? Hazim Mustafa went on to Sky News and he said, look, here's my SARS declaration, here's everything. John Steenhuisen and the DA sent a letter to SARS and said, hey, do you have a copy of this declaration? Can you share it with us? SARS said, no, we got nothing from Hazim Mustafa. So what was he showing Sky News? Then he refused for the Sky News people to take photos or copies of that particular declaration. Why? If it's legit, why are you hiding that information? I think he's a liar. He didn't avail himself to the Section 89 panel. The South African Reserve Bank said they couldn't find him. How could this guy who was found and speaking to Sky News, all of a sudden nobody can find him anymore? Nobody can. I don't trust. And because of that, I think there's a need for an impeachment committee to actually get to the bottom of that story. Because you say it on Sky News, here are the documents, but now you are nowhere to be found when everyone else who has legal authority to... What are we doing here? Are we going to buy that version at face value? I don't think we should. I think Hazim Mustafa definitely is a liar, or the version about Hazim Mustafa in and of itself is a lie. Because if he was so honest, so truthful, so robust, why didn't he provide a sworn statement? Also, I think it's dubious that the president himself didn't provide a sworn statement to the Section 89 panel. And he created a buffer. Mr. Ndlovu is a hearsay person because he says, no, this is what Mr. Ndlovu told me. Why didn't Ndlovu give a statement to the Section 89 panel? That statement a sworn statement would have given his ID, all of these other details. He didn't do that as well. So it's a problem. It's a problem. The panel pointed out, and I think it's important to point this out as well. The president complained that Fraser had relied on hearsay evidence, but he relied on hearsay evidence according to the Section 89 panel, because he said, this is what Mr. Ndlovu told me. And then the panel also said something very important. The acknowledgement receipt that was provided to them had insufficient details about the transaction. They stated that what they needed to see was the tax invoice, which would have given them the IDs of particular individuals, passport numbers, etc. And these documents were not provided to them, even though the transaction was done on Christmas Day in 2019. Also the day, guys, Christmas Day, Father Christmas arrives with $600,000 and then he buys buffalo that he never takes. What are we doing here? What are we doing here, right, in terms of some of this stuff? We can't think about all things based on the man in the arena. So if it's Zuma, we're tough. If it's Ramaphosa, we're like, nah, he's a good guy. He's doing good things. Let's overlook certain things. So I think that some of the arguments that have been made by Wim Trengove in these heads of arguments are not compelling. I don't think that they are compelling. I think that what has happened here is that a political party acted to protect their principle before that matter, before the conference. Because remember, this all exploded just before the elective conference of the ANC. And I think that it would be a travesty if this particular impeachment procedure, which is supposed to be robust, is hollowed out by a judgment which then says any political party, as long as it has the majority, can simply dismiss anything that comes out of a Section 89 panel without having to go to the next stage and simply say, no, it's faulty, they don't have evidence, when they didn't have capacity to actually get the level of evidence that they need. Either these rules are bad and they need to be changed, or these rules are okay, and what the Section 89 panel did was okay. What do you think, though? Let's have a conversation. Till the next one.